Anne is a staff lawyer with the West Coast Environmental Law, the oldest environmental legal organization in BC. She's been in providing various groups with environmental legal information and advice to British Columbians, as well as representing community groups. First Nations has been consulting with the BC government, including key environmental law reform priorities, provides legal education, advocacy tools, and how to reverse the federal government's gutting of environmental laws, which Otto has gone at some length. And so Anna's going to bring us up to speed on the various environmental legislative changes. Anna Johnston.
Thank you very much for having me here. I'd like to thank the Sechelt Band for hosting us on their beautiful territory, and to the SCCA for organizing this event, and to all of you for coming out on this gorgeous Saturday to sit inside and watch slideshows. I have to say that if you're trying to keep the coast a secret, you're doing a pretty terrible job. Great. Okay, thanks. Okay, so I'm going to be giving a brief overview of the federal legal landscape. So as many of you know, in 2012, our core federal environmental laws were gutted by two major omnibus bills, Bills C-38 and 45. I'm going to start off by providing a little backstory to what went on to make those changes occur. In the late 2000s, DFO undertook consultations on the Fisheries Act in an effort to modernize it, and especially the habitat protection provisions. They consulted with a number of different groups, industry groups, provinces, environmental groups, and out of all of those recommendations, it's industries report back to the government on the changes they want that are the most interesting. In particular, industry, we have, sorry, I should explain how I know this, we have access to information documents that show all of the consultations. And so we have industry's report that says that industry was complaining that the habitat protection provisions especially were too broadly applied. The threshold for harm was much too low, and that they didn't want to have to be accountable to both provincial and federal governments. They found all of that red tape to be too onerous a burden. Around the same time, there was a 7-year review of the Canadian Environmental Assessment Act that again involved a number of different groups, stakeholder groups, environmental groups. And again, industry made a very similar suite of complaints that the timelines for projects were too long, they were being dragged out by various environmental and community concerns. Proponents were frustrated that they had to undergo both provincial and federal environmental assessments, or even just one assessment, but under both laws. Too many projects, they said, needed to get assessed for their impacts. And then in 2011, we have a letter from the EFI to our Minister of Environment, and Joe Oliver, as you can see here, suggesting that they have some major recommendations for the whole suite of environmental laws in Canada. The Energy Framework Initiative is a group of industry associations that were some of the major players in the consultations under the Fisheries Act and the Canadian Environmental Assessment Act. So about a month later, we saw the letter come out from Joe Oliver, the open letter that talked about how radical environmental groups under foreign funding were getting in the way of the diversification of economic development in Canada, which really began the kind of witch hunt on environmental groups across the country, but especially in British Columbia. There's quite a bit of writing there. I won't expect you to read all of it. It's, I'm happy, I should say that I'm happy to provide any of the documents that I referred to in my presentation. I'm happy to just come and talk to me after and give me your email and I can send them to you. So later on in 2012, then we saw bills C-38 and 45. In C-38, we saw the Fisheries Act get significantly amended to reduce habitat protection, to expand federal powers. We saw the Canadian Environmental Assessment Act repealed and replaced with a new one. We saw the Species at Risk Act amended, and also the Kyoto Protocol Implementation Act repealed. A few months later, the Fisheries Act was gutted even further. The Navigable Waters Protection Act was significantly amended to remove protection of over 99% of Canada's lakes and rivers. The outcry, the public outcry to these changes, and I'm going to be describing each of these in turn, but the public outcry was huge. Thousands and thousands of Canadians represented by hundreds of organizations, former DFO, or former fisheries ministers, 3 former fisheries ministers formally wrote the government to oppose these changes. Scientists from across the country, from around the world opposed them, and the changes were brought into, all of these amendments and changes were brought in completely unaltered from their original state in the omnibus bills. So, the Canadian Environmental Assessment Act, now CA 2012, the major changes that occurred in that act, probably the most significant one is that under the new law, only projects that are listed in regulations get an environmental assessment. So the way that it used to happen, any project that required federal permitting, federal funding that occurred on federal lands that involved the federal government in any way, it received some form of environmental assessment, whether it was a screening assessment or the more robust comprehensive reviews. Now, if it's not listed on the schedule, it doesn't get assessed. So what that meant was that about 90% of the projects that used to get environmental assessments by the federal government no longer get an environmental review. In the month following the enactment of Bill C-38 and the new CA 2012, about 3,000 environmental assessments were canceled across the country. The new act also narrows the scope of the effects that are considered in environmental assessments. So it used to be that heritage and human health and cultural effects were considered they were just considered to be environmental effects. Now they're only considered in limited cases. It also imposes mandatory timelines, which has been a very, very major obstacle to groups and to individuals who are attempting to participate in environmental assessments. As we saw in the environmental assessment of the Site C Dam, I represent a community group up in Fort St. John, and they were very, very challenged to get their experts to be able to review the materials and to draft their own reports in time for the mandatory timelines that the panel had to impose in order for the review to be concluded within the mandatory timelines under CA 2012. And so it's really crippled people's ability to bring forth meaningful information into the review process. It also allows for the federal government to substitute provincial assessments for federal ones. So it used to be the case that the federal government always had to have some sort of a role to play. BC and the feds often collaborated on joint environmental assessments. Now, if the provincial government requests that the federal government substitute the federal process for the BC one, the federal minister must say yes if she deems it to be an appropriate case for a substitution, which essentially just means that if she approves it, there is no federal assessment. The feds just rely on the provincial assessment, which is a even weaker assessment process than this new federal one. So since the implementation of this act and the memorandum of understanding that the province and the feds entered into approximately a year ago, I think, every substitution request that the province has made, I think it's 10 or 11 now, the feds have approved. So we've just seen the end of federal environmental assessments in British Columbia. So the Fisheries Act gets even gloomier. Probably the most significant amendment to the Fisheries Act was the reduction in protection of fish habitat. It used to be the case that any harmful alteration, damage, or destruction of fish habitat was prohibited under the Act. You had to get a permit from DFO in order to harm fish habitat. Now, serious harm to fish habitat is prohibited. And so they've raised that threshold a little bit. Instead of just doing harm being prohibited, the harm has to be of a serious nature. The one sort of saving grace about this is DFO came out with policy a little bit after this provision was brought into effect. And DFO policy has taken the kind of the best case scenario interpretation of what serious harm is. It's still just policy, and that's actually created quite a few more questions about whether or not industry groups are going to start to litigate if DFO holds this threshold of serious harm to the lower threshold of the old provision. So it's raised all sorts of questions about what constitutes serious harm and how many of these not so serious harms can occur before the cumulative impacts of all those less serious harms really begin to add up. Another very significant amendment was the elimination of protection of fish habitat for non-fisheries fish. So now, instead of, it used to be the case that all fish were protected under the Fisheries Act. Now, these protection provisions only apply to fish that belong to a commercial, recreational, or aboriginal fishery, or the fish that support such a fishery. Again, raising all sorts of questions. Your guess is as good as mine. Otto probably has the best idea of what's going to constitute a supporting fish. Fisheries fish are any fish that are regulated by provincial regulation. I've talked with DFO conservation officers who have taken the position that all fish in BC will retain protection because they all essentially fall under some sort of a provincial fisheries regulation. But then I'm working with a community group on the island right now that are opposing the harvesting of seaweed on the beach, and that seaweed is habitat to God. Well, herring, yeah, but yes, sand lance and something else. Anyways, so they've been consulting with DFO. DFO hasn't issued a permit to authorize this harm to fish habitat, nor have they, despite repeated requests by this community group, approached the company that's doing the harvesting to tell them that they need to get a permit. And they have said that they have not determined whether or not the sand lance are covered by the new habitat protection provisions. So what we're starting to see now is that certain species aren't being protected under the new provisions. The amendments also enabled Cabinet and the Minister to, it gave them extra powers to completely exclude certain species of fish. Cabinet now can just exclude an entire species of fish from the habitat protection provisions. She can exclude an entire water body from the habitat protection provisions. They can, I believe its Cabinet can also authorize certain individuals or groups or provinces, or say an industry group, authorize them to have control over issuing those permits to do harm to fish habitat. So a much broader expansion of the government's powers to enable harms to occur. The Navigable Waters Protection Act is now the Navigation Protection Act. It was amended in Bill C-45 in a few different ways, but the biggest way was that it, as with the Canadian Environmental Assessment Act, the Navigable Waters Protection Act used to protect all navigable waters in Canada. So anything that you could either float a stick down or a canoe down was considered a navigable water. Now, only waters that are listed in a schedule are protected by the main protection provisions of the Navigation Protection Act. About 99% of Canada's lakes and rivers are no longer, they're not listed on that schedule, and so they've lost their protection. So for example, there's not a single water body on Vancouver Island that's protected under the Navigation Protection Act. Powell Lake is, the Pacific Ocean is, and the Fraser River is, but that's about it for around here. I might be running out of time. So it also, It also expanded government's ability to authorize certain harms. It removed the requirement that proponents give notice for projects that are going to interfere with navigations, and so that really restricts anybody's ability to understand projects that occur around them and to participate and to give their say in projects that could affect them. So the relevance of these amendments to the coal issue is it's quite possible that had SIA 2012, for example, not been brought in, that the Texada Island coal storage facility would require some sort of a federal review, because under the old act, anything that required a federal permit needed to get a federal environmental assessment of some sort. We've heard today, and we're going to hear more about how there are all sorts of concerns that the coal storage facility is impacting fish habitat, polluting waters, which would have probably triggered the requirement for an authorization to do harm to fish under the old Fisheries Act provisions, right? So now they've raised that threshold, so maybe that's not serious harm. But a couple of years ago, it would have been harm, which would have likely triggered an environmental assessment. So what we see is, in this situation, this is arguably one of those on-the-ground impacts of the federal environmental law changes. We've removed public participation rights, we've limited people's ability to have a say in the decisions that affect them, we've stopped reviewing projects for their environmental impact, and we've allowed much more harm to occur to the components of the environment that we care about most, without requiring proponents to apply for permits, to give their environmental review studies, to have any science showing what the impacts of these projects are going to be and whether or not those impacts can be avoided or just shouldn't be authorized at all. So it's a pretty gloomy note. I'm going to leave it on what you can do. I have a petition in the back, on that green table in the back, on the left corner there, just calling on the federal government to repeal the changes to the Fisheries Act, to enact a stronger sustainability assessment act to make sure that the impacts of all of our decisions really work towards the sustainable development of our communities and our environment and our economies. You can visit our website, envirolawsmatters.ca. I try to frequently post new materials, news stories about federal environmental law changes that are occurring. They're continuing to be gutted as right now the federal government's contemplating regulations under the new provisions of the Fisheries Act that will get rid of the requirement for fish farms to obtain authorization to dump aquatic drugs and pesticides into water. So this is still going on. So go to the website, sign the petition. I have literature in the back, and come and speak to me. I'm always available to answer questions, and thank you for having me.